Today we're diving into the case that defined Australian copyright law before 2009, when a tech company thought they could just copy the entire phone book. This is Desktop Marketing v. Telstra, and it's about to get interesting. Imagine this. It's the late 90s. Telstra, the telecom giant that basically runs Australia's phones, spends absolute millions every year creating those massive phone directories. We're talking 55 regions, millions of subscribers, constant updates. It's like Pokemon, but for phone numbers. Gotta list them all. Enter Desktop Marketing Systems. They look at all that beautiful, organized data and think, why should we do all that work when Telstra's already done it? So Desktop does what any rational, definitely not legally questionable business would do. They literally copy Telstra's entire white pages and yellow pages into their own database. And when I say copy, I mean copy. Like that kid in school who didn't just copy your homework, but also copied your name at the top. Bold move, Sam. Telstra finds out and they're like, you did what? And boom, lawsuit city, population, desktop marketing.
Now here's where it gets juicy.
Desktop's lawyers stride into court with what they think is a bulletproof defense. They're like, Your Honor, it's just names in alphabetical order. There's no creativity here. A through Z has been around since, forever. You can't copyright the alphabet. They even pulled out this American case, Feist v. Rural Telephone, where the U.S. Supreme Court basically said, yeah, phone books need a creative spark for copyright, and alphabetical listings are about as creative as watching paint dry. Desktop's feeling pretty confident. They're thinking they've found the legal equivalent of a get-out-of-jail-free card. But here's the thing about Australian law. We do things a bit differently down under. The trial judge, Justice Finkelstein, basically said, nice try, but this isn't America, mate. He ruled that Telstra's massive effort, we're talking serious labor and expense here, was enough for copyright protection. Desktop appeals, thinking the full federal court will surely see reason. Justices Black, Lindgren, and Sackville are presiding. The stakes? Whether you need creativity for copyright, or whether good old-fashioned hard work counts. Court drops the hammer. Appeal dismissed. The judges basically said, look, in Australia, we respect the sweat of the brow. Telstra spent massive resources collecting, verifying, updating this data. That's enough for copyright here. They distinguished the American Feist case, essentially saying, that's nice for America, but we've got our own legal traditions, thank you very much. The court pointed to a long line of British and Australian cases protecting industrious collection. So what's the takeaway for Australian law before 2009? First, just because something seems obvious, like alphabetical order, doesn't mean it's free to copy. Second, Australian copyright law values hard work, not just creativity. If someone's put in substantial effort and resources, you can't just yoink their work. Third, what flies in America doesn't necessarily fly here. Different countries, different rules. This was the law in Australia until 2009, when things changed with the ICE TV case. But that's a story for another video. Desktop had to pay Telstra's costs and learned an expensive lesson. In the copyright world, there's no such thing as a free lunch or a free phone book. Thanks for watching, and as always, keep imagining.